Okay. Start. Okay. Was he on drugs? Was he just too enamored with his girlfriend? It's like, yeah, get rid of that useless man. I'll pay the lawyer. I'll pay off the house. I'll pay off your useless husband. I'll pay the mortgage. He must have been drunk, right? Something, on drugs, something. So this does raise the issue that the promise is gratuitous. It does talk about what's at issue, which is about the mortgage, but it doesn't really matter what it is, does it? Or does it? Does it matter whether he's offering to pay off the mortgage or pay for the car or pay for a year's supply of candy cane? Does it matter what he's...
Yes, because in all these things different value.
Well, they have different value, but the other thing is, you know, what he's offering to pay for involves a court proceeding. So that's different, right, from saying, I'll buy you a car. Don't worry, Daria, I'm going to buy you a car. You're okay. But the fact that this is something going into court, that influences how this works out, right? And what's one reason? Elvis says, I'll pay the lawyer. So it's interesting because in this case, Elvis didn't go find some lawyer and he didn't look somebody up on the internet. Was no internet at the time, by the way. Didn't look anybody up in the phone book. Find a lawyer. Here, can you represent my girlfriend's mother to get rid of her useless husband? No, he uses one of his lawyers. You know, Elvis is rich. He's got all kinds of lawyers, accountants working for him. He just tells one of his lawyers, go help Joe Laverne. Go help Joe Laverne get divorced and get rid of that useless husband. And so that creates an extra complication, doesn't it? Why? Well, Elvis dies, and then his estate, the lawyers representing his estate say, we're not going to pay that mortgage. And so that creates what? A conflict with the lawyer. Elvis's lawyer is representing Joe Laverne, and now Elvis and Joe Laverne are adverse. So that lawyer, he can't represent them both. This is a little class in legal ethics. So what does he do? I got to represent either Joe Laverne or Elvis. He sticks with Elvis, right? He's making a lot of money working for Elvis. Okay. What else could you put into this issue that would, you know, make it a little more precise to describe the issue in this case, describing the issue to the judge? So we got one side of it. It's a gratuitous promise. What's the other side of the question? Why is there a question of whether this gratuitous promise should be enforced? Because normally, right, somebody makes a gratuitous promise, it's, you know, there's no question about it. I can say, Anastasia, I'm going to give you $1 million. That promise is what? Gratuitous. It's without consideration. Can Anastasia take me to court? No. So we already know gratuitous, that's one side of it, not enforceable. But so what is the issue in this case that even raises a question? Maybe this is enforceable. Maybe the gratuitous promise is enforceable. What's the question?
Did the plaintiff rely on this promise?
Exactly right. So the issue, as described here, should say something about, that's the issue, really. Forget about the mortgage, forget about the gratuitous promise. is, did she rely on the promise? That's really boiling it down to the issue. Elvis was drunk one night, promised to pay for the divorce and the mortgage. And then if they woke up the next morning and she said, okay, Elvis, pay me, he could say, no, forget it, I was drunk. But once she goes into court, gets the lawyer, gets the property settlement, and who thinks that this case was, in the end, the court says she was not reasonable in relying on this promise. Does anybody disagree with that? You're the lawyer in this case for Joanne, Ginger's mother, and you're trying to convince the judge, you're wrong. What about what the Court of Appeals said? That was one of the questions on your 20 questions.
They said that she relied on this promise because she rejected remedies available to her in the divorce petition.
Yeah, and that might be true. I mean, they might be right. She did things, didn't do things in her divorce case. First of all, would she have ever agreed to pay her husband for his half of the house and assume the mortgage if Elvis hadn't promised to pay for all that?
No.
No. And did the whole thing, that whole transaction, get fouled up because Elvis died and then his lawyer said, we're not going to pay? That left her in a crack, put her in a bind, didn't it?
Yes.
And I guess the question here is, I'm not sure it's clear from the facts. Has she already paid her husband? The court says you could have gotten out of the property settlement because it wasn't final yet. The court decree wasn't final. And so when you went back to court the second time, even though you already had a property settlement agreed to, you should have asked the court to get rid of that property settlement because Elvis wasn't paying anymore. They said they're not paying. Has she already paid her husband? I'm not sure. I don't remember if not, but would that make a difference? She's already paid her useless husband. So she's out the money. And she ends up taking, is that a fair divorce settlement? You're getting divorced, you have a house, you each own half of it. So you own half of the value of the house. You also are each responsible for the mortgage, the debt you owe on the house. So you're going to settle your divorce and tell, your useless ex-husband, okay, let's settle this. I'll pay you for your whole interest in the house, and then I'll take on all the debt. How's that for a divorce settlement? It's terrible, right? It's terrible for Joanne. But, the court's kind of funny. The court goes on and said, part of the reasoning is Joanne and Ginger are much better off for having known Elvis, regardless of whether he paid the mortgage. What does that mean? Well, the court's assuming that the whole time Elvis has been, this isn't the first promise Elvis has made. Maybe Elvis has already given them a Cadillac, given them a new car, built her a swimming pool, took him on a trip to Bermuda, bought him a house in the country, maybe bought Ginger a pony. So the court's going, Elvis was doing all kinds of stuff for them. Is that relevant? It's not really relevant to this transaction, is it? So if you were Joe Laverne's lawyer, what would you be arguing? If you heard the judge is up on the bench, sometimes in these court hearings and trials, the judge will sit and they'll talk and tell you what they're thinking. The judge says, Joe Laverne and Ginger, I think y'all are much better off. Elvis has bought y'all cars and taken you on trips and bought you clothes, and you have some jewelry Elvis bought you. So it doesn't really matter if he pays your mortgage or not. What do you argue if you're Joe Laverne's lawyer? Judge is talking like that.
Elvin's promise induced her to assume a mortgage.
Yeah, so she has had a detriment. She's had a detriment. And you'd also argue, Judge, none of that has anything to do with this transaction. The judge is looking at everything Elvis has done for them. And if you're her lawyer, you say, Judge, that's nice, but that's got nothing to do with the specifics of this transaction. Let's look at what is in front of the court. What's the evidence in front of the court? And we're only talking about this transaction and nothing else. And whether he gave him $100,000 a year ago is irrelevant to whether he stuck her with a mortgage now by making by not keeping his promise. All right. So anyway, that's just a little exercise. If we were a smaller class, like a clinic, we'd be like doing these specific examples all the time and working through them. But that gives you an idea how you need to think as a lawyer, how you need to respond to the judge, how you need to refine the issue. So that issue, it was good in certain ways. It was trying to be specific, but it left out a pretty important issue, didn't it? The issue of the real issue is, did she rely on the promise, which was not in that answer. So as a lawyer, make sure you zero in on the most important thing. Lots of lawyers, and I have to say this, especially, I think it's true more of European lawyers. I've done a lot of work in France. I have a lot of French attorney friends, and they think it's a very fundamental difference. They think the more we talk, the better. And they'll get up and go on for hours talking about how many angels can dance on the head of a pin. And they think that's great. They're going on. We're very eloquent, talking for hours. In the United States, we have a totally different idea, which is get to the point and get to the point fast. And I think maybe Ukrainians, maybe more like Americans. But anyway, that's what you want to do. Zero in. If you don't zero in on the most central issue, you haven't quite done your job good enough. So you can't talk about the issue in this case without getting to whether she reasonably relied on Elvis's crazy promise. We know the promise is crazy. I mean, but did she rely on it is the question. Speaking of questions, let's look at these questions I gave y'all, and I had 5 people send in answers. So let's look at some of these answers, and y'all tell me, y'all think this is a good answer, bad answer, should improve the answer. So y'all have the questions in front of y'all. Remember, I said y'all 20 questions. You should follow along, look at your questions. Question number 1, in Elvin v. Associates, did the court hold that Aretha Franklin breached the contract? Can anybody blurt out the answer real fast? What's the right answer?
No, the court held that there was no contract because Aretha had never signed it.
That is exactly right. And yeah, and that's exactly what I'm looking at your answer. That's what it says. Let's look at another answer. The court did not find Aretha Franklin had violated the contract in the case of Elvin Associates versus Franklin, which concerned a claim of breach of contract against Franklin's production company that was resolved through an out-of-court settlement. That, you hear the difference in those? So that's one answer. This, another answer is no, the court held there was no contract because Aretha never signed it. Let's see what else we got. Here's one answer. The court found that the defendant had breached the contract. Is that right?
No.
No. Because what do you have to do to breach a contract?
To have this contract.
You have to have a contract before you breach the contract. And the court held there was no contract. So you see, the professor is vindicated again, because the beginning of the class where he says, oh, professor, you're telling us about all these theories. But the theories are important. They're practically important, because here's a case where the court held there is no contract. So there can be no breach of contract. So, okay, you're the lawyer. Oh, the court says there's no contract. So I can't get a breach of contract claim. So where am I going to go? I need another theory, right? I need another theory to recover. So the theories are not so bad. I'll say, professor, theories, you're giving us theories. But the theories are very important. When one theory of recovery doesn't work, oh, maybe there's another theory. So that's why you have to be very specific and follow the thread of all these different theories in your mind. And of course, the other big difference is the remedies, right? What if the court had held there was a contract, even though Aretha never signed it? They did everything. And remember in this basketball player case, what did that court say you had to have a contract? They say you have to have a signature. Usually you do have a signature on a contract, but what did the court say you have to have a contract?
Consideration and
Yeah, that's one thing.
And the claim should be timely filed.
Well, timely filed, that's always true in court. There are procedures that you have to be aware as an attorney. There's a certain amount of time you have to file a claim. It's called the statute of limitations in English. And so if somebody hurts you and you wait 10 years and go like 10 years later, you say, I think she breached her contract, I'm going to sue her. What happens when you go into court 10 years later? Too late. Statute of limitations, right? You have a certain amount of time. You didn't do it fast enough. Doesn't matter what the facts are. Doesn't matter what the law is. You lose. You're out of court. Didn't do it in time. But in Iverson, they talk about the two things they talk about for a contract are the intent to be bound and consideration. So looking at this, applying that to Aretha Franklin's case, did these parties express mutual intent to be bound by the agreement? Well, may I ask you an easier question. Was there consideration for this agreement? That should be an easy question. Was there consideration?
No.
Why not?
Because he got nothing.
Well, if you were to say there was an enforceable agreement here, if there was a contract, was there consideration for the contract? Did the producer get something? Did Aretha Franklin get something? And I would say, yes, there's consideration. She's going to get paid, right? Is getting paid consideration? Yes. Somebody says, I'll pay you 25% of the ticket sales. That's consideration. That's money. Money is always consideration. Somebody gives you money. So they're all going to make money. What's he going to get? Aretha Franklin's going to perform in his show. She's going to get paid. He's also going to get paid, he hopes. So there's consideration. This is not a gratuitous promise. He doesn't say, Aretha, would you go down to the Kyiv National Opera House and just sing for us? Go out there and sing for us for free. Is that, they're not talking about that, are they? They're talking about, no, a business deal. They're making money. She's getting paid. He's getting paid. This is not exchange of gratuitous promises. They're talking about making money. So there's consideration. But what about intent to be bound? Did both parties express an intent to be bound by this agreement? Were there any terms they were still arguing about? Had they agreed on the amount of money?
There was a condition that the agreement can be enforceable only after making this performance.
Yeah, so there was that, you're right, there was that sentence hanging around in there saying that that this is our understanding until we have a more formal agreement, something like that, right? But was this their final agreement? So you're lawyering one side, you say, this is not a formal agreement yet, so this was not, not a contract yet. But you're arguing the other side, lawyer on the other side said, we had agreed on everything. There's nothing left to agree on. This is our formal agreement. Only thing left was to sign it. Is there evidence that everybody had an intent to be bound by what was already written down? Even though Aretha Franklin never signed it?
Yes.
Why?
Because they talked about and offer their conditions.
Well, she was supposed to sign it when?
When she go to the New York.
Yeah, she had agreed. She hadn't signed it, but she had agreed to sign it, and she was going to sign it the first day of rehearsal. Yeah. So you could argue there's if the standard is, was there consideration? Yes. Money is consideration. Was there intent to be bound? You could argue, yeah, they intended to be bound by this promise. Everything they'd written down in these contracts, even though she hadn't signed yet, there was intent to be bound. So if you use the standard from the Iverson case in the Aretha Franklin case, you could say, if you were a clever judge, you could say, I'm saying this was a contract. You could do that. Of course, problem with that, because there's a little bit of an argument about it, because of that sentence that Tatiana pointed out, what can happen? And this is important to understand as a lawyer. You might win your case. You gotta make your argument, win your case. But what do you not want to happen next? When you win, what's the worst thing you can think of happening? I won my case, but it was appealed. There was an issue that wasn't completely clear. I argue Aretha Franklin intended to be bound. But there was a little bit of doubt because there was this little sentence in their previous paper saying, until it's a more formal agreement. So what do you have? You have an issue to what? To appeal. When you win your case, what's the worst thing you have? You go to court, you have a case against somebody, you win $100 million. You go celebrate, I'm going to get $100 million, but not so fast, because what's going to happen next? What's the party who lost, who was ordered to pay you $100 million? What are they likely to do? They're going to go appeal. They're going to go appeal. And you don't want an issue that an appeals court could look at it and say, yeah, I don't know, this $100 million, that's a little doubtful. Because look at this, there was this sentence in the contract. You could say that that was not a contract. So remember, when you're a lawyer, you don't just want to win your case. You don't want any issue hanging around in your case that gives the other side a ground to appeal after you won. So clean up your case. Don't leave anything like that lying around. Okay. Yeah. Have a couple of people answered that yes, the court held that Aretha Franklin breached the contract, which, if you're answering that, you need to read a little more closely. And remember, where's the confusion come from? It comes from the fact that there are different legal theories in this case. So I can see why somebody was confused. Also, maybe reading the case in their second or third language makes it harder too. But because part of the reason there's confusion is that the producer in this case, Singer, is that his name? He won on some issues and he lost on some issues, right? So ultimately, you could say maybe he won his case because the court ordered Aretha Franklin to pay him money. I won. The court ordered her to pay him money, but on the theory, but not on breach of contract. And again, I say, if I'm Singer, I'm not real happy with this case. I'm going like, I lost this case. Because what does the court order Aretha Franklin to pay him? She has to pay his expenses, right? Everything he's paid or everything he owes has to pay somebody. Court says, Aretha Franklin, you got to pay him back. So here's a good lesson for lawyers and their clients. These people have gone around a couple of years in court, and where does Singer end up? It's better than nothing, but he gets what he lost. He gets the money he paid for expenses. He gets it back. What if the court says, yes, there was a breach of contract? What are the
Then
damages?
he can
You get expectancy damages for breach of contract. What are expectancy damages? What does it sound like? What I expected to get if the court said,
the contract will be done.
yes. So he gets, like, as if the contract never existed, he gets back to where he was. That's better than he was. He lost money, right? He paid expenses and then there was never a show. And the court says, well, I'm going to put you back where you were as if there was never a contract, because that's the reliance damages. You paid money out, you get that money back. But he spent several years working on this project, working on the project, and then working on the lawsuit, which is not to be laughed off. It's a lot of work. And And he's done all that and not made any money, right? He's just back where he was 2 years ago. So that's not a good business result. But expectancy damages for breach of contract, as Tatiana said, as if the contract were performed, as if they'd put on all these shows and sold the tickets. And he got his 25% or whatever he was supposed to get. There's a lot more money, we hope. Okay. So question number 2, under what legal theory did the court hold Aretha Franklin liable? Now this answer says she unreasonably relied on a promise that the heirs had reneged on. Is that a right answer? Actually, I think
No.
mixing up the cases. I think this answer is talking about the Elvis case, not the Aretha Franklin case. Let me try another one here. Aretha Franklin was found responsible for Springer's expenses by the court under the legal principle of promissory estoppel, which is true, but that's a long way to say that. Just say promissory estoppel, judge, promissory estoppel, which enables a party to seek damages even without a formal agreement, which is true, based on a pledge made by another party that the first party relied on to their detriment. That's all true. That's the definition of promissory estoppel. Although it's a little wordy, but it's all correct. Okay. Let me see. Got another. Okay. Again, we got somebody else who said she unreasonably relied on a promise that the heirs had reneged on. That's the same answer. And it's also talking about a different case. So y'all are working together on your answer. Be careful who you get help from. If you're going to get help on your answer, make sure you get help from somebody who got the answer right. Don't get help from the person who got the answer wrong. Okay, and then this, the court held Aretha Franklin liable for Springer's expenses under the theory of promissory estoppel. That's correct. Okay. Question 3. In the Elvis Presley case, it's a little confusing because we have the Elvin case and the Elvis case, but the Elvin case, that's Aretha Franklin. She doesn't show up for rehearsals. The Elvis case, that's Elvis Presley, the king of rock and roll. There wouldn't have been Beatles or Rolling Stones or anything without Elvis. But in the Elvis case, why was Elvis's promise gratuitous? And it says, considered gratuitous because it was not supported by any what?
Consideration.
Magic word, consideration. There was no exchange of anything of value between Alden and Presley that would create a legal obligation. And is that right?
Yes.
Yeah, that's the definition. That's a definition of consideration. So that's all correct. Here we got another answer, another stab at it. Why was Elvis' promise gratuitous? Because he made a unilateral promise, he did not receive a reciprocal offer for his promise. What do you think of that answer? That's an interesting answer. It's almost right, and that's an important contract principle. Did whoever gave that answer, you want to answer like what is a unilateral promise? What does that mean? Nobody knows. Okay. So usually in a contract, you have mutual bargaining. People, the two sides are bargaining. They say, I'll take this and I'll give you that. But there can be a contract created unilaterally, meaning it's created by only one party by holding out a promise And it usually means if you meet this condition, I will keep my promise. And it usually happens on something like, I hope this has never happened. Did any of y'all ever lose your cat? Lose your cat, lose your dog? Dog ran away from home? No. It happens in America all the time. It's a little wilder here. Dogs and cats running around free everywhere. Lots of times people lose their dog and they'll put a sign out on the telephone pole. I lost my dog. $500 reward. If you return my dog, I'll give you $500. Is that a contract?
It's offer of contract.
It's a what?
Offer.
It's an offer. That's correct. That's good. It's an offer. But if you bring the dog, can the person say, I don't have to pay you. It was just an offer.
It's contract.
Yeah, it's a unilateral contract. It's a promise made by one party that sets the conditions for I'll keep my promise if you do something, right? And so one way, if you look at it in terms of offer and acceptance, the acceptance is bringing the dog. Here's your dog. I accept the promise. So, so has Elvis made a unilateral promise here? He made an offer. And see, that's interesting because this gets to my point again, why the theory that you use is very important. What if this is a unilateral promise? Elvis has held out an offer to make a unilateral contract. What do you have to do to accept a unilateral promise? Think of the example where you return the dog. You have to do what the person who made the unilateral promise asked you to do. So if you're looking at this, I'm sorry?
She should get the divorce?
Yes. If you make a unilateral promise, how do I accept a unilateral contract? By doing what the person asked me to do. So if this is a unilateral promise, I will pay you if you get the divorce and you get rid of that worthless, sorry, good for nothing husband of yours. I'll pay. If this is a unilateral promise, is it a different result? Maybe. And this is how they torture American law students. They throw out all these possibilities. So you never know, you're never sure. And it's true in court, you're never sure what the judge is going to do, but you have to understand these theories and make these arguments and understand, and it's especially important in contract law, the theory you're using, what you're asking the court to do determines, one, are you going to win or lose maybe, and also what you're going to get. What if Aretha Franklin had signed the contract? What if she'd signed and then she didn't show up for rehearsals? And so Singer got his lawyer to go down there and sue her. And the lawyer only sued her for promissory estoppel. Said she didn't keep her promise. She didn't show up for the rehearsals. What's the problem? The problem is you're going to fire your lawyer, right? Because the lawyer messed up. She signed a contract, so there is a contract. There can be breach of contract, but your lawyer says, I'm not going to worry about the breach of contract because we have her on promissory estoppel. She didn't keep her promise. We don't need to worry about suing her for breach of contract. Let's sue her for promissory estoppel. She has to pay. What's the problem? Why are you going to fire your lawyer?
Because of money, you can get more money.
You
if
can
there
get more
was a
money
conflict.
under the breach of contract. So if you're if your lawyer says, don't worry about the breach of contract, we've got her dead on promissory estoppel. We're not even going to sue her for breach of contract. Not only do you fire your lawyer, you end up suing your lawyer for malpractice because the lawyer gave up a claim that was better. It's a better theory than the one he used. Don't worry, we're going to win under promissory estoppel. Well, I am worried because we didn't win as much money under promissory estoppel. I don't care that we won. We left money on the table. Remember Tom Cruise, show me the money, show me the money. That's what y'all are doing most of the time as lawyers. Okay. So, unilateral promise, interesting idea, but probably wrong because the unilateral promise is you're going to do something for the person who made the unilateral promise. Like the person who said, I'll give you $500 if you I lost my dog. If you find my dog and bring it back, I'll give you $500. Is Joanne doing anything for Elvis by getting divorced? No. Well, unless maybe it doesn't say, maybe Elvis is interested in Ginger's mother. Maybe he likes Ginger's mother better than Ginger. He'd like her to get divorced. He'd run off with his girlfriend's mother. Well, that could happen. With Elvis, you never know. Okay. Question number 4. Did Elvis make a legally effective gift to his girlfriend's mother? He said, I'll pay for your divorce. I'll pay for your mortgage. Is that an effective gift? I see you shaking your head. So say it. Don't just shake your head.
No.
No. In court, you have to speak. If the judge asks you a question and you shake your head, no, that will not cut it. You got to stand and deliver and speak out and, express your position for the judge. I don't know, maybe so. That's not going to win it with the judge. So, it was not a legally effective gift. Why not?
Because of failure of delivery.
Yeah. To make a gift legally effective, you got to give it up. You can't just promise. But if he'd actually paid the mortgage, that's delivery. Okay, you're Ginger's mother's attorney. How do you argue there was a delivery of the gift? What's your argument? Maybe not on every claim, but remember, the other thing as a lawyer, there are lots of different issues here, right? There's different little pots of money. There's the mortgage. There's the paying off her husband's interest in the house. There's paying for the lawyer. So as a lawyer, you might analyze all those separately. Don't just throw them all into one big pot because you might have a better argument for some than others. You might win some and lose some, as they say. Out of all those, where's one where you could argue it was a gift because there was delivery? The
He
gift
paid
was
for attorney.
Yeah, that lawyer showed up, right? That's delivery. So again, I hate to do this to y'all, but lots of people say the court got this wrong. So I don't know why they do this in American case law tech. They teach us all these cases that are wrong, and we're supposed to learn the law from that. It's hard, but it's good for you because you can never be complacent. You got to stay on your toes. Okay. All right, let's skip ahead because we got to get off of Elvis and get to, we got a half an hour to cover. Poor Blackman. Who feels sorry for Blackman? Who is Blackman? Who am I talking about? We're moving on to the next case. All right, don't shrug your shoulders. Who's Blackman? You don't know. The case, Iverson versus Blackman, Iverson versus Blackman. Who's Blackman? Well, let's start. Who's Iverson?
Basketball player.
Famous basketball player. And what happens with famous basketball players in the United States? They go to the NBA, the National Basketball Association, become professional basketball players, and make millions of dollars every year. Iverson, he's making big money, big money. Show me the money. They showed him the money. Who's Blackman?
He was a coach.
Maybe sort of, but he's known Allen Iverson since he was a kid, right? He's a longtime friend. And was Allen Iverson rich when Blackman met him?
No.
No, he's a poor kid in the projects. Born a poor black child. And so and it's a question whether that's a factor in the case. Blackman argues that. It's like, I've been seeing after this Iverson since he was a kid, since he was a knee high to a puppy, and looking after him and helping him guide his career and everything. What do I get for it? Nothing. So, but okay. What was the promise that led to the dispute? Is question number 8. What was the promise that led to the dispute in Blackman versus Iverson?
Iverson promised that he would give 25% of the proceeds from the merchandising of products.
Yeah. And in particular, merchandising of what products? Products with what on them?
With the nickname The Answer.
With the nickname, The Answer. And who thought that up?
Blackman.
Blackman. That was Blackman's idea, right? So he not only had the idea for The Answer. Y'all think that's a good nickname? Yeah, I don't know. I don't know. Doesn't strike fear in the hearts of the opponent. Here comes the answer. I don't know. Sounds a little corny to me, but remember, what was the point of that? What did that mean? The answer. Why did Blackman think of that?
He can be the answer of the question to NBA.
Yeah, he'd be the answer to all the NBA's problems. So I guess we're assuming in that time, the NBA is not doing very well. It's not very popular. People aren't watching it on TV. They're not making, as they do now, like the NBA playoffs are going on right now. It's on TV all the time in the United States. They pay, here's a good job for you as a lawyer to negotiate the contract for those broadcasts. Millions of dollars. That's the contract you want to get in on. But apparently NBA not doing so great. So Allen Iverson was going to be the answer to their problems because he was such a dynamic, exciting player that everybody watched the NBA just to watch this guy play. He was so good, so flashing with brilliance. I don't know, but he doesn't sound that good to me in retrospect. So Blackman comes up with this idea, we should call you the answer. And then Iverson says, that's it. We call you the answer and put it on t-shirts and hats and stuff. And Iverson says, that's a great idea. I'll give you 25% of what we make. How many times, question number, how many times did Iverson make the promise to Blackman?
At least 5 times.
Yeah, we don't know. They list about 5 times and they say he made more promises. He made the promise in front of other people. What's the importance of that? You're the lawyer, and you have some cases where he made the promise in front of a third party. Why is that important?
There are witnesses.
Yeah, so that's not contract law, that's evidence. So we're not in a dispute. Did he really make that promise? Yeah, well, no, we know he made the promise. He made it in front of people, including in front of who? The lawyer. He made it in front of his lawyer that we're going to pay Blackman 25%. How did Blackman rely on the promises? Well, let's go back first to, does it matter how many times Iverson promised? Is that important? Interesting question, right? According to this court, the way they came out, the court doesn't seem to care whether Blackman promised 100 times. Do they? They promised 6 times. He promised 6 or 7 times that we know of. But the court doesn't seem to think that's important. But you make a promise. What issue might that go to? Like he promised over and over. What does the court say you have to make a promise enforceable?
Consideration.
Well, consideration is one thing we talked about. What's the other thing we talked about in terms of when we're talking about Aretha Franklin? We asked, did Aretha Franklin show what? Remember we said there's consideration, they're paying money, they have all these contracts back and forth, and she's agreed to sign it as it is, and that shows what? Her intent to be bound.
Sign.
Well, even though she hadn't signed, I would argue she intended to be bound by that contract. She's supposed to sign it the day of rehearsals. She intended to be bound. So if that's the question, and that's what this court asked, they say, is there consideration? Was there intent to be bound? What about intent to be bound? Did Iverson show intent to be bound by his promise?
Yes, because he repeated his promise.
Yeah, I think that goes to intent. You said it one time, maybe you wasn't thinking, maybe he hadn't talked to his lawyer yet. He made the promise over and over, including in front of his lawyer, right? Lawyer sitting in the room, he made that promise. That's sort of like, what other case did we read? Remember, they opened the box and get out the papers, and Sophie promises, we won't ask for our share of that property if you don't ask for any share in this property. That's sort of like that's the way the court is looking at it. That basically saying Iverson made a gratuitous promise, right? He made a promise, there's no consideration. but he keeps making it over and over and over. What if, let's take the Aretha Franklin facts. What if Iverson had sat down with Blackman and they'd written all this out in a contract? We're going to have this deal with Reebok. You know what Reebok is? It's a shoe company. Deal with Reebok, and they're going to put Allen Iverson, the answer, on all their shoes and t-shirts and hats, banners, and it's in the contract. And because Blackman has looked after me my whole life, and he came up with this idea, not only of the answer, the nickname I'm going to use, but the idea of using it to sell all this merchandise, all these clothes. I'm going to pay him 25% and signed it, Allen Iverson. What happens then? Is this a different case? Different result? They signed on the dotted line. What do they have? They have a contract, right? So can Iverson get out of it by saying what? There was no what? Considerations. That's an interesting question you'll always get into. How far along are you in the formalities? Once you've signed a contract, you can go back and say, well, there was no consideration for that promise. I know that's tougher to back out of, right? You know, the formalities of a contract. And so, and that's different from, you know, in this case, the court asked Blackman how he relied on Iverson's promise. How did he rely on the promise? How did Blackman rely on Iverson's promise?
He claimed that there was he didn't made a claim of promissory estoppel, but if he wanted, he could say that he relied on that promise because he had been continuing to offer ideas and even moved to Philadelphia.
Yeah, he worked on it and he moved to Philadelphia, of course. But what's the problem with claiming promissory estoppel? Court says you might win promissory estoppel claim, but what's the problem with that theory?
Less money.
Yeah. What would be the damages? Iverson has to pay for the cost of moving to Philadelphia, right? But what else? Your Blackman's lawyer, what else might you argue? So he spent all this time working on designs. Why is that not important to the court?
Because they didn't use his designs.
They didn't use his designs. And this reminds me of a case. Y'all get Coca-Cola commercials in Ukraine? They come on TV, say buy Coca-Cola.
Yes.
You ever seen one? They used to show them around Christmas time with polar bears in them.
Yes.
There was a huge Coca-Cola campaign where they had all these polar bears. And of course, it conveys this idea. It's so cool and refreshing. We're at the North Pole, we're drinking a Coca-Cola. Makes me feel so good. Of course, it's not that great to be a polar bear these days with global warming and everything. But anyway, they did that ad campaign. I worked at a law firm in Atlanta, and we had a case on behalf of a guy who sued Coca-Cola because he had gone to them with this idea of using polar bears in their advertising. And he had all these drawings he'd done up, little polar bears. And Coca-Cola says, nah, thank you. Thanks for the idea, but we're not going to use it. Goodbye. And then what do? Big ad campaign, even seen in Ukraine, selling Coca-Cola with all these polar bears sitting around drinking Coca-Cola, right? So do you think the guy won his case? Sues Coca-Cola. Came to you with the idea of polar bears. You did all these commercials with polar bears. You didn't pay me. Well, y'all have no way of knowing, but he lost. And because Coca-Cola, and this, I don't know if this is good or bad, gives you an idea how in business to, you know, what the contours of bounds of the law are, but they didn't use his drawings. They had somebody, and actually their drawings were better. They went and hired some artists who did really cool looking designs of polar bears that didn't look like this other guy's polar bears. So he lost. The court said, you know, that, you know, your claim was not specific enough. You said, I said polar bears, they use polar bears, but their polar bears didn't look anything like your polar bears. You agree with that? I don't know, maybe so. It's hard. It seems unfair, right? It's not fair. Poor guy. Coca-Cola probably should have paid him to go away. Let's settle. Yeah, you brought us the idea of polar bears. We use polar bears. It will pay you a little money. Thank you. Let's not have a lawsuit. What about Allen Iverson? He's promised. Yeah.
He misappropriated the idea and the concept of the answer.
Well, he took it and used it, didn't he? Now, misappropriation, that has a very specific legal meaning that he took somebody else's idea improperly. He definitely appropriated the idea. Misappropriating means he did not have a legal right to do it. Of course, here the court says he did have a legal right because, again, like the polar bear, like the idea was not specific enough. You agree with that? Here's the question I would have put to the court. Okay, so Blackman comes up with the idea of the answer. And Iverson uses that. He uses it his whole career. And the court says, well, that's not novel. That's just a word. Anybody could have thought, but is there any evidence that somebody else thought of that besides Blackman?
No.
Yes,
No. Who said yes?
I,
Okay, what's your reasoning?
because it was no idea to sell products with logo.
Well, that's so, again, this is a good example of how you frame the issue. When you're a lawyer, you want to make the court frame the issue you want to. So here's how the court views it. It says, putting logos on a t-shirt for a sports star, that's not a new idea. Everybody does it, right? So that's the answer. It's not novel. What about the exact nickname, the answer? The court's like, well, anybody could have thought of that. Is that true? You know, some of these cases come up because somebody has the idea and then somebody else has had the same idea or similar idea. And then they argue about where the idea came from. But there's no evidence in this case that anybody else ever thought of the answer. Here's a math problem for you. This is a probability question. If Blackman hadn't come up with the idea